Welcome to today's program. My name is Doug Reeder, and I'm the chairman and a co-founding partner here at Sterling Seacrest Partners. We're really pleased to have you join our call today. We've got a really good program and some great presenters, me excluded. For those who don't know us on the call, we're a multidisciplinary commercial insurance agency practicing nationally from 6 offices in the Southeast, with deep industry verticals in healthcare, construction, real estate and hospitality, transportation, logistics, nonprofits, and personal insurance risks. We also have a large benefits consulting practice, which works with businesses of all sorts, design, implement, and administer group benefit plans. We're very pleased to have David Merbaum and Andrew Becker with boutique firm of Merbaum and Becker, who are going to talk to us about challenging contractual provisions in construction contracts for which you need to be on the lookout, and they'll also discuss strategies you can deploy to negotiate them and or mitigate their impact. I'll follow that with an update on emerging risks, market issues, and some news on a couple of exciting new insurance products. David began his legal career focusing on the representation of surety companies and contractors. He was responsible for handling all aspects of surety claims and participated in numerous trials and arbitration hearings. In 1996, David started his own firm, Merbaum Law Group, in Alpharetta, Georgia. In 2016, the firm was changed to Merbaum and Becker PC to reflect the additional partner, Andrew Becker. Andrew's practice area includes construction law, business litigation, landlord-tenant, credit debtor, and civil appeals. Andrew has experience in drafting appeals to the Georgia Court of Appeals, the Georgia Supreme Court, and the Federal Court of Appeals for the 11th Circuit. Merbaum and Becker represents contractors, subcontractors, landlords, tenants, small businesses, and material and sporting goods supply companies and matters throughout the United States. The firm handles cases involving construction law, commercial collections, landlord-tenant, incorporation, real estate matters, including real estate litigation, business advice and dispute resolution, and consumer advice and representation. The firm is also able to assist clients with initial communications through litigation or arbitration and the appeal process. Please join me in welcoming David Merbaum and Andrew Becker.
Thank you, Doug. Well, good morning, and thank you for joining us. Doug said, my name is Andrew Becker, and I'm one of the partners at Merbaum and Becker. And for our first presentation this morning, we're going to talk about challenging contractual provisions and how to deal with them. What we've done is we've picked out the contractual provisions that we have found cause the most litigation or financial damage to our clients. Now, we're not going to talk about all possible difficult contractual provisions. We're going to talk about the ones that probably lead to the most litigation. We're going to take a look at what they are, what they look like, how to deal with them, and like a stereotypical attorney, I'm going to talk out of both sides of my mouth and discuss why you would want them and why you don't want them.
Shut it down.
There you go. All right. So before we get into the actual provisions, let's talk about some best practices. So what happens when the majority of people receive a contract from their customer? Well, in our experience, they confirm the price is right. They review other terms and conditions that they think relate to their work, and they skim the rest. You have to read everything. Details are incredibly important in your contracts. What you need to do is for every contract you have, highlight what you don't like or you don't understand and ask your attorney to review it if you have any questions or concerns. The only person looking out for your business is you. Even the AIA, consensus doc, and the other so-called standard form contracts are problematic. Why? They're made to be edited. Just because it's an AIA 101 or 201 doesn't mean it's the same as the last AIA A101 or 201 that you saw. Remember, Many of the form documents will show where they have been edited, but this can be excluded and overwritten. David and I have both seen many instances where AIA documents were altered in ways that were not readily apparent. So in those instances, our unsuspecting client all of a sudden found that even though there were no marks on the contract showing it had been changed, it actually was. And under Georgia law and the laws of most states, if you have an opportunity to read the contract, you are going to have a very difficult time in court convincing the court that you were tricked. I look at the contract review process kind of like boxing. The idea is you have to protect yourself at all times. There is no referee that's going to stop the other side from taking advantage of you if you're not looking. Let's talk about our first challenging provision, which is the pay-if-pay provision. Now, most subcontractors and contractors are familiar to one extent or another with the pay-if-pay provision. I would say it's almost somewhat infamous in the contracting world. So what is it? Well, you only get paid for your work if your customer gets paid by its client. Failures by others can result in non-payment. They require very specific language to be enforceable. However, they are generally enforceable in Georgia as well as the majority of other states. They are prohibited in certain states based on public policy concerns. It's always interesting to talk with someone who is not in the construction industry about pay-if-pay contracts, because it's almost as if you're saying, I'm going to walk into Best Buy, I'm going to buy a TV, and I'm going to tell them that if for any reason I lose my job next week, I don't have to pay them for the TV. Are they going to give you the TV? Absolutely not. They're going to look at you as if you're crazy. However, that is the reality in the construction world, and there's good reason for it. The classic example is a bank refused to loan the project owner money. The owner can't pay the general contractor, and so the general contractor does not have to pay its subcontractors. That's the basic idea and why the pay-if-pay provision is necessary on most projects. However, over the years, pay-if-pay provisions have been expanded somewhat. So we see something these days like the owner deducts liquidated damages from the general contractor's final payment. The general contractor then proportionally reduces payment to all its subcontractors, regardless of fault. So you're a subcontractor on a project, you did nothing wrong, your pay-app's now reduced by 20%. Is that enforceable? Well, in Georgia, there is no case that says it isn't. The fact that these provisions are prohibited in certain states should give you an indication how problematic they can be. So what do they look like? This is the important part of this presentation, is for all of us to know how to spot them. So what I've done is, this is a snippet from a real contract. We have redacted the name of the general contractor so they don't get a little upset, though this contract was subject to litigation. The key language you're looking for is anything that says there is an express condition precedent to the contractor's obligation to make payment to the subcontractor. Key word, express conditions precedent. You might also see absolute condition precedent. When you see this, you are dealing with a pay-if-pay provision. They are normally located in the payment section of the contract, but they can be located elsewhere. We've seen them as separate addendums. We've also seen them in the liability section. It is exceptionally difficult to argue a waiver of a valid pay-if-pay provision we have had a case where the general contractor said, I am going to pay you out of my own pocket. And they did. And the court still found that was not sufficient for the general contractor to waive the pay if paid provision. Importantly, this includes payment for change orders, not just payments for regular contractual amounts. It doesn't matter that the owner signed the change order. Doesn't matter the general contractor signed the change order. If the owner never pays the general contractor for that change order, they do not have to pay you if you're the subcontractor or the subcontractor. Now, there is a wrinkle with this, is that there are some states, South Carolina is one of them, where they are prohibited, and where even if your contract is governed by Georgia law, you can run into a situation where you're not, if you're the general contractor, you're not actually protected. So you have to be careful and look at the laws of the state where you are performing your work. Why do you want them in your contract? Don't want them in your contract. Well, obviously you can do everything right and still not get paid for your work. At certain points, you are essentially financing the project. And importantly, you can't pass it down to your suppliers. I don't know of any material suppliers that in a purchase order would agree to a pay if paid provision with their subcontractor. But why do you want it in your contract, in your subcontracts? Well, it prevents your client's insolvency issues from becoming your own. And this is important because there are many instances where in the middle of a project, someone loses funding. You don't want to be caught in the open where you're obligated to pay someone for work where you're not getting paid. And that is the traditional reason why general contractors should always, always, always have a pay if paid provision in their subcontracts. Now, there is a number of ways to address them. However, one of the things that has become apparent in our practice is that if you're the subcontractor, it is very difficult to get them out of the contract. It's not as easy as just striking that provision and returning it to the general. You have to have a significant amount of leverage. Instead, what we try to do is try to limit it to insolvency scenarios. So we try to exclude any non-payment that's caused by failures of other parties. You're not responsible. If you're the plumbing subcontractor and the electrical subcontractor has a failure on the project, you shouldn't be responsible for their failure. Also, we're going to include the right to cease all work if undisputed payments are not made within a certain time. Now, it might seem that you have this right anyway. Well, as we're going to discuss in a little bit, that's not always the case. There are instances where you're stuck working without payment. Protect your lien rights, and this also includes your bond rights. The real remedy for a pay if paid provision where the owner has filed bankruptcy or is insolvent is your lien on the property. And as David's going to discuss in a little bit, that is something that you have to keep your eyes open for. That is the best defense to the pay if paid. The final part, no matter whether you're a general contractor or a subcontractor, the best way to address a pay if paid, besides filing a lien, is to include them in your subcontracts to pass along the burden. One of the themes I hope everybody takes away from this presentation is that any challenging or adverse provisions in your contract should be mirrored in your subcontracts. Whatever you're stuck with, the people who are working for you should be stuck with those same provisions. If not, you're going to get caught in the middle.
But if you're a first-tier sub and you're providing your own labor and your own buying material direct, I mean, you're stuck with it if you don't.
That is correct. Then if you are at the bottom, as they say, something flows downhill. Unfortunately, that happens here. The best defense is a lien, because you have to pay your own employees, you have to pay your suppliers. There's no one to pass that burden down to. Now, the next of the challenging provisions is what we term no damages for delay. What that is that you are not entitled to monetary compensation for any delay damages caused by others. The only remedy you're entitled to is an extension of time. And again, like the pay of pay provisions, it's been expanded over time. We're not just talking about a delay. We're also talking about inefficiencies and just about anything else that makes your work more expensive. It is enforceable in Georgia as well as the majority of other states. It is prohibited in a minority of states based on public policy concerns. And that, again, should give you an idea of how problematic a pay of pay provision can be. Sorry, a no damages for delay provision can be.
Do you know any of those off the top of your head?
I believe that, I want to say California and Massachusetts have restrictions on how they can be used. Most states do allow them to one extent to another. In the Southeast, they're fairly well established. So, what do they look like? Well, again, we've taken a snippet from a real contract, and again, this contract was subject to litigation. You're looking for keywords like delayed with, interrupted, or caused to proceed in an inefficient manner. Then you're looking for language that says sole and exclusive remedy, only time extensions but no monetary damages. So you're looking for a provision that talks about delays, interruptions, and then quickly, either in the next sentence or in one or two sentences further on down, says that you are not entitled to any money. Why don't you want them in your contract? Well, as most subcontractors and contractors know, you can suffer serious financial harm due to delays without any recourse. As an example, you're working on an out-of-state project, and so your employees are staying in hotels. The general contractor changes the schedule, and you're forced to stop work for a week. You can either fly your employees home or continue to pay for the hotel and keep them idle for that week. Whatever you choose, under a no damages for delay provision, you're out of luck. Besides you suffering serious financial harm, your customer lacks an incentive to protect you from any delays because they don't have to pay you for the consequences. Why do you want them in your subcontract? Well, number one, flexibility and scheduling. You might not know every instance where a schedule change will cause a delay to your subcontractors. It might be difficult to ascertain how much of a delay and how much it might cost. And so if you're the general contractor, you absolutely want this in your contract. It also prevents costly disputes. Delay damage disputes are long and complex. There's a lot of different ways to value them. Some of you might have heard about the Eichley formula. Some of you might have had experience dealing with a CPM analysis expert. Sometimes the experts on delay damage cases cost more than the delays and the attorney fees combined just because they're so complex. If a party is not entitled to any actual damages, it streamlines that dispute, and the only question is, how much additional time does the party get? How are we going to address them? Well, again, like pay provisions, they are difficult to simply strike out. What we like to do, we like to go through and try to carve out exceptions like out-of-pocket costs. So looking at the prior example we talked about with the out-of-state employees, in that instance, that would be a direct out-of-pocket cost, and it would be compensable. Allow for an assignment of rights. What this means is that if your subcontract says you're not entitled to any delay damages, you can take an assignment of rights from the general contractor against the party that actually caused the delay. This is not a very good idea for small delays, but on a larger project where the delays might be 100,000 or over, at that point, it actually does become a viable way to recover your costs. As we talked about, include them in your subcontracts to pass along the burden. Can't stress it enough. Whatever adverse provisions you have to deal with should be mirrored in your subcontracts. Talk about unilateral schedule modifications. Exceptionally common.
Before you jump to that, do you ever see, like where you would almost negotiate like an inverse liquidated damage where you'd say, you know, if I lose a day, it's worth this much, you know, where that is something that they would agree to?
We have tried that a number of times, and sometimes that works. It works a little bit more often when it comes to setting a price for mobilizations and demobilizations. Mm-hmm. Sometimes you can put unit prices for employees. If we have to have employees idle, this is how much it costs. One of the biggest issues is that if you go down that road, you then have a situation where you have to be able to justify those costs up front. Sometimes in the process of justifying those costs, you end up having to pull aside the curtain a little bit as to how you bill out and what your real profit is. And you have to be careful because you don't want your client all of a sudden to know how much profit you're getting on those employees. At that point, they might try to renegotiate. They might try to cut down in other areas. It is a good idea. And one of the things that David and I both try to do is you have to think outside the box sometimes. You have to think, okay, well, they are not going to just pay us for our delay damages. What can we do? Can we say, look, there's a cap. If there's a delay that lasts more than 2 days, we'll get $1,000 a day for up to 10 days, and that's it. We don't get any more. So everybody knows the worst case scenario. Sometimes that works. It depends upon how much leverage you have. If you're a specialty contractor and the general contractor needs you, then it works. Right. The same token, if you're a general contractor and this is something the owner is trying to throw down you in the contract, at that point, they might have 5 or 6 other bids and just simply say, look, we're going to go to the next one down the list. Right. Thank you. So what do we have for unilateral schedule modifications? Well, customer has complete control over the scheduling and sequencing of work. There you go. You are not entitled to any additional compensation for schedule and sequence changes. May include the right to suspend all the work on the project. May require you to demobilize and remobilize for free. So what do these look like? Well, we have a snippet from a real contract. The key language you're looking for is that the contractor shall have the right to decide the time, order, and priority by which the various portions of the work will be performed. This, you might also see absolute discretion. So, and this provision can appear in a variety of different places. It can appear in the scheduling section of the contract. It can appear in the payment section. It can appear in the claim section of the contract. It's not in one place. Why you don't want it in your contract? Well, I think it's obvious. It can cause delays. It can cause inefficiencies. Cause you to have to accelerate without compensation. And cause labor shortages. Now, one of the biggest issues we see these days is inefficiency issues. And this is really important because in a challenging contracting environment where everybody is trying to save costs, people make assumptions. As an example, you have a drywall subcontractor who has a contract for a 5-story hotel. For the subcontractor, the most efficient way is to go from the top down, room by room, floor by floor. The general contractor has issues with other trades on the project and so instructs the subcontractor to go every other room, every other floor. All of a sudden, that subcontractor's game plan for the project has turned into an exceptionally inefficient approach. Under the unilateral schedule modification, they have no claim. It's highly problematic, and that loss of efficiency can cause serious cost overruns. But why do you want it? Flexibility in scheduling. If you can get it in your contract or your subcontract, you absolutely need to. For the same reason, no damages for delay provision is necessary. You simply don't know all of the different eventualities on a construction project. It's possible that in the middle of a project, something might occur beyond anybody's expectations, and you have to reorder the work. If you don't have a free hand and you're worried about getting hit with delay damages, then you're going to have a problem. How do we address them? Well, what we try to do is to try to limit the pain. We try to exclude acceleration, overtime, and weekend work. One of the biggest issues we see with unilateral schedule modifications is that it's a way for the general contractor to accelerate a subcontractor's performance simply by changing the schedule. Subcontractor might think, looking at the drywall example, that it's going to have one crew because it has 2 months to complete its work. All of a sudden, the schedule changes to 1 month. It needs 2 crews. It doesn't have the employees. What does it have to do? It has to go hire another subcontractor to help it out on this project. That subcontractor is now taking profit and overhead. They're losing money. Include demobilization and remobilization fees. Most contracts these days have either the owner or general contractor has the right to suspend performance. In those situations, sometimes performance can be suspended 60, 90, 120 days. If you have to pull off the project, you're going to incur costs. Try to monetize those costs. As Doug, as you just asked a few minutes ago, that's where you would try to put a set value on it because everybody should know how much that's going to be. The owner should know how much it's going to be so that they are less inclined to just simply suspend the work. If there is something specific in your contract that you assumed in order to perform the work efficiently, make sure that's in your subcontract. Many times we have stated that they are allowed to change the work, the schedule of the work, but it can't impact the subcontractor or general contractor in the following ways. That protects everybody. Finally, again, mirror them in your subcontracts. continuing performance provisions are kind of, sometimes they're hard to explain, and they're even harder to defend when you're on the receiving side. What they are, very simple. You must continue working during a dispute. The validity of the underlying dispute does not excuse your non-performance. The failure to continue working can result in extreme financial liability. For instance, you have a subcontractor who disputes a certain item worth about $2,000 is included in its scope. There's a dispute with the general. They abandon the project. General contractor hires a completion contractor for twice the price. Even if the court finds the subcontractor was right as to that scope issue, they were wrong leaving the project, and they are liable for all of the additional costs incurred. You go from a bad situation to a far, far worse situation. We try to tell our clients, crawl over broken glass to finish. If you have a continuing performance provision, you will be in a much better position. You can't leave. It will be a horrendous problem.
What percentage of contracts that you guys look at have continuing performance provisions?
80%.
Yeah.
And I have to say, every general contractor should have it. There's absolutely no reason why a general contractor shouldn't. And when we see a general contractor's form contract that doesn't include it, it is concerning, because they are leaving themselves open. What does it look like? Again, another snapshot of an actual contract.
You mentioned a couple times before that this was subject to litigation. I just wanted to clarify. You're saying that because this is in the public record.
Correct.
All these provisions that you're
Correct.
illustrating.
We have to be
I
careful.
just want to be clear that that's why you mentioned that.
Oh, no. These are all provisions that have already been disclosed, because one of the things that is problematic in the construction industry is that there are certain contract forms that are confidential. And so unless they were subject to public disclosure, we couldn't present them here.
Right.
The key language for these continuing performance provisions is that the subcontractor has to continue performing despite the existence of any dispute or legal proceedings. That's the key word. They can be in the scheduling section, they can be in the payment section, they can be in the dispute resolution section, or even part of an addendum, or just part of the miscellaneous section of the contract. They can be one line. It can be anywhere. That's why you have to read everything in detail. Why you don't want it in your contract? Well, as a subcontractor, there's a lack of leverage. You really don't have any ability to get the general contractor or your owner to deal with the issue immediately. Financial liability. You can end up having to pay material costs and labor costs well before you know whether you're actually going to win the dispute and get reimbursed. The biggest one is it just kicks that issue down the road until the end of the project, which could be 6 months, a year and a half later. All the while you have to deal with those costs. Why do you want it? Well, this way you can't be held hostage by your subcontractor. Your subcontractor can't simply say, well, we're in a dispute, you owe me $1,000, I'm leaving. We have had this happen a number of times. We've litigated it, and we have had a number of subcontractors that have been surprised when they got hit with very large judgments, because they thought they were right, and in some cases they were, but they stopped working.
Andrew, you're talking about these provisions today that we should be able to look out for, but there are provisions that you may want to include, which calls for a face-to-face meeting if issues arise during the job, so you can sort of cut things off at the pass. I went to a site yesterday, there was a provision that said if we have a dispute, let's go and meet face to face and try to work it out. And we did that, and everyone left basically unhappy because that's how things worked out. But they knew that one guy had to stay on the job, and the contractor knew the sub was going to remain. And it's a way to address problems not only at that moment, but going forward, especially if there's an issue with how someone's managing the job or how they're being treated on the job. They say, going forward, this is why we're having these issues. Let's try to address it.
And exactly, when we go to address, how do we address them? We'll go to the second bullet point, immediate mediation. You have a provision that either you meet individually or you meet with the mediator and you try to get it resolved immediately. What we've had some luck doing is crafting provisions that cut off disputes over a certain value. You don't want to have to continue working if you have a dispute that is worth 50% of the initial contract price. The idea behind this provision was it's $1,000, we can't slow down the project to deal with $1,000. If it's 50% of $1 million project, that's a lot of money that the subcontractor or general contractor is going to have to put up while the project is going on without any knowledge as to whether they're ever going to be reimbursed.
What have you had some success doing there, in terms of percentages or dollar,
15%.
15.
20% seems to be a magic number that everybody can agree that if there's a dispute that is worth more than 15 or 20% of the contract, then the continuing performance clause isn't actionable. It doesn't mean that if you're wrong, you're not still liable for all the damages. It just means that if you're right, you can walk off the project. It's your choice. It's a risk. You have to be right. But the other way didn't matter.
And if you've got the continuing performance clause coupled with the clause that says we can direct how you're going to do the work, you're really in a lot of trouble. Then you're boxed in.
Again, if you have to keep working, your subcontractors have to keep working. You mirror those provisions. Final one we're going to talk about is something that seems to become more and more a problem these days, and I've termed them scope expansion provisions. There's really I haven't heard of any global term that's universally accepted. So what are they? Well, they're provisions in the contract that act like a dragnet of sorts. They add additional labor to your scope, add additional materials, and they override bid exclusions. The idea behind them is that they're going to capture any work that wasn't specifically detailed in the plans or specifications, but is related to your work. Okay, we have another example. Key language here, and other items reasonably inferable. We have, 5 words here? That can be an awful lot of money. This happens when you have someone bid on a project, they have a listed set of exclusions, the contract is issued, the bid or the estimate is not attached, therefore, everything is now fair game. That reasonably inferable, even if it's not in the specifications, you are bound to perform. It might just be a few screws, or if you are only trying to bid on half a mechanical contract, it can drag in an awful lot of other work. Why you don't want them in your contract? Requires you to do work you did not bid on. Requires work excluded in your estimate. It acts as a really nasty surprise when you submit a change order and the owner or the GC come back to you and say, sorry, it's in your scope. No change order.
Did I hear you say that you want to include your spec in your scope in the contract is what I heard there, right?
Correct. And if you have it, we're going to get to it, but
To make sure that it's included as an exhibit to the contract.
the best way to deal with this, if you're excluding certain items, attach your exclusion list as an exhibit. That is the only way you're going to prevent it. Why you want it in your subcontracts? Well, again, on the other side of things, if you're the general contractor, you need this. This way you don't have holes in your bidding or estimates. You can be certain that if you bid out the plumbing scope, you're covered. You don't have to worry that you forgot to list one item in the spec. You don't have to worry that there's a page missing or something's missing from a set of plans. If it's reasonably inferable that would have to be performed, you have to perform it. So, Doug, as you said, you just include that list of exclusions as an example. And surprisingly, that is something most people are hesitant to do, primarily because they think that it's already part of the contract. Unless your exhibit or proposal is attached as an exhibit or incorporated by reference, it is not part of the contract. It's meaningless.
I think that's news to me. I mean, that's really practical,
Well,
impactful.
they have these provisions, we call them entire, agreement provisions. It says unless it's in writing and part of the agreement, that's it. So typically, if your, estimate or quote is not included or attached, it's
It's
not,
just a separate
it's not part of the
document.
contract.
Yeah.
It doesn't matter.
Wow.
You can have every other email in the world discussing an exclusion. That contract is the Bible. That's what you have to work with. And if you have to deal with it and you have subcontractors, you pass it down. That is also a way to protect yourself and go, look, if I have to do it, you have to do it. Let's talk about just some, again, best practices. We said you have to read your contracts in detail. Run important contracts by your attorney. The amount of money it costs for an attorney to review a contract pales in comparison to litigation. There's a mediator we use who has an expression that you can't waive at a courthouse for less than $50,000. And that is true. It's probably a lot more these days. You can spend basically a de minimis amount to go through, clear up these provisions, save yourself time and money on the front end, not have to deal with it at the end.
I just want to add a comment there. My wife happens to be a Superior Court judge, and one of the, I think, underreported stories of the pandemic is how far backlogged the courts are getting as a result of the failure to prosecute trials and hearings and so forth because of the pandemic. So the money you spend reviewing a contract compared to trying to litigate something in court is, in the current environment and the next backlog years that we're going to face, it's absolutely a no-brainer.
And Doug, you hit the nail on the head. You could be waiting 5 years
Yes.
to get relief, and even if you win, you then have appeals. You have attorney's fees. Deal with it on the front end. Don't wait. If you're the general contractor, you should have your own form contract to give to an owner. Don't let the owner give you their contract. It's going to save you a lot of money if your contract, you know it, you give it to the owner, they can make the changes, but it's in the form that you like. Don't be the one receiving the contract. If you're a subcontractor, that's a little bit harder.
And
It doesn't work as well.
And I find it very interesting because we coach our clients to send them to their attorney, send them to us, let us, scrub down the insurance, the indemnities. And it continues to amaze me how often the subcontract is terrible, but because it incorporates the general contract, we also get a copy of that, and it's a streamlined AIA document. And I think just having that and knowing that is helpful to negotiating changes to the subcontract, because the GC has not accepted all the stuff that they're probably passing down through because they signed a stripped down AIA up here. And I think a lot of subs who don't go through that process, you know, they're missing that opportunity sometimes to maybe negotiate or put exclusions on the contract.
And you hit a really good provision. When I went through the list, I had about 20, and I'm known around my firm as being, David can tell you at our firm, I'm a little verbose. And I looked and I said, well, if I do 20, we won't be out of here until 6 p.m. One of them was almost every contract includes, by reference, the prime contract. You have a whole other contract you need to review because all of its terms, at least as far as your work are concerned, apply to it. And we have to tell our clients, you take a look at the listing of documents that make up the contract. It's not just the subcontract. It's the prime contract with the owner. It's all the plans, all the modifications, everything. So there's a lot there. We have a lot of, I'd almost say it's almost like a list of boogeymen in a contract that when I go through it, I just look out for.
And we've had very little pushback when we've asked our subcontractors because the subcontract makes reference to the prime contract, but it doesn't tell you what it is. But we've asked for that prime contract, and we have always gotten it.
Yeah.
Now they may retract it, you know, the amounts and all that, but we've been very successful in getting that.
I think the general contractors are a little. I think they're getting the idea that if they're going to include it by reference, they need to provide it.
It is getting easier, I think.
Yeah.
Yes.
One of the reasons is that most of the time in the subcontract, it makes reference to liquidated damages that the general contractor may be assessed. They might be $1,000 a day. They might be $100 a day. They might be $100,000 a day. There's been a couple of large projects where they were $50,000 a day. If you're a little sub, but you're critical, and there's any way you could delay the project, your contract might be for $50,000, and if you delay the project 5 days, you're at $250,000. You need to know that because that's a lot of risk for not a lot of reward.
Right.
So you have to be careful, and sometimes we just say, look, when the prime contract's liquidated damages are just crazy, we have to limit them to no greater than, let's say, 25% of the contract price. We just simply can't be on the hook for everything because if not, we can't do the work.
Right. One related topic that I would add is that, you know, when you're negotiating your subcontract and requesting the prime contract, we strongly recommend that you request the builder's risk policy that backs the construction works, that insures the construction works, because you are insured under that policy, and you should know whether it's good or not, how big the deductibles are, you know, if there's any holes in it. If we're your insurance professional, we're happy to review that for you. If we're not, you should absolutely have your agent review that, because there are many cases where we find, you know, big gaps. And so exposures that is inuring to the subcontract that could be insured or could be negotiated into the builder's risk policy.
Doug, you're exactly on the deductibles. Again, you can have a very high deductible, and it can state that those contractors that are at the project site during the incident will all share equally in the deductible. That could be a $10,000, $20,000 deductible. And again, if you don't have a large contract, it is really problematic.
We have a question, and the answer is yes, you can. That's absolutely correct. And again, it's worth noting that you are an insured under the policy by design. And so that's why you should, you know, you have a right to look at it because you're relying on it to protect you in the event that there's, you know, a covered cause of loss that would be covered under the builder's risk program. So it sometimes takes some educating general contractors, but usually you can get to a person on the project team that understands that policy is meant for everybody working at the job site, not just the general contractor and not just the owner.
And they have no reason, in reality, they have no reason to hide from you.
Right.
It's not, I mean, it says what it says. You're going to be able to take a look at it at one point. Better to discuss it in advance.
Yes.
Now, I will say one of the things that we get questioned a lot, we have clients who call us on the phone who are aware of all the different provisions, and they say, well, where are they located? The cop-out answer, but the truest answer is anywhere. I can tell you that there is nothing that says they have to be located in any particular section. I have seen AIA contracts that are modified where all of a sudden, in the middle of the insurance provision, you find the pay if paid. Someone thought of it like insurance, and they put it there. I have no idea why, but it was there. And if you skim the insurance thinking, oh, it doesn't matter, I have policies, you're in trouble.
Right.
The last two bullet points go together. So one of the things that I didn't say during this presentation was strike it out, strike it out. Why? The provisions we've talked about, it's really hard these days to get a general contractor or an owner to strike them. You need a lot of leverage. Modification is the easier road. In many instances, your attorney can modify it to take the real sting out of it. Like on the pay if paid, there's always situations where, yes, the owner is insolvent. You are not going to get paid. That one I can't help you with. But I can help you with the situation where the general contractors, other subcontractors delayed the project. The general got hit with liquidated damages, but you were off the project for 6 months before any of that happened. That we can deal with. Final thing I'll leave you with today, because contracts are great. Contracts given to you by someone else should always be suspicious. You need to protect yourself at all times. I just love that boxing analogy, because you are standing there and you just can't assume, even if you worked with someone for 20 years, you can't assume that they're looking out for you. There's a lot of times that we get angry subcontractors or general contractors who are upset at the owner or the general contractor because they've worked with them on project after project. They never knew that there were all these provisions that hurt them. They looked at them as their friend. They might have been their friend, but this is a business world. Being a friend is one thing. Having your contract written so it protects you is simply something else.
Absolutely.
So protect yourself at all times. And again, have your contract reviewed by somebody who's experienced in reviewing contracts. Can't state that enough. You can prevent so many issues on the front end. Oh, yeah. I'll use the bottom one.
The last screen.
So my name's David Merbaum, and while they're loading up my screen here, let me just reiterate that construction projects are just an opportunity for disputes from start to finish. And if you're ever in a situation where you think leaving the job is your best course of action, I will tell you the vast majority of times that is a mistake. You really need to try to find a way to work through whatever issues, because you're generally giving the other side a blank check to finish your work, charge extreme costs, overhead, administrative costs, and delays. So if there's any way you can finish jobs, you need to try to find a way to do that. This topic, I have liens, bonds, and a whole lot of odds and ends, and it's something I've given before. And we're basically going to focus, however, today on liens and bonds. And the timing of the seminar is good because there's been a recent change to the laws as they relate to lien waivers, which has been a lot of cause of consternation for subcontractors and suppliers in Georgia, the way we have it set up. And we'll get to that in a little bit, but the timing is good because the law is going to change in about 3 weeks. So these are the topics we're going to address, but like I said, when we get toward the end, I'm probably not going to get to a lot of it based on time constraints. So we'll have a little overview of liens. We'll speak about lien discharge bonds, lien waivers in particular, what's called affidavits of non-payment, whether you can amend a claim of lien, the effect of a false affidavit on your lien rights, the delivery of materials if you're a material supplier to undeveloped property, where you have projects in more than one county, anti-assignment clauses. There's a recent case from a few years ago which now does impact your deadline to foreclose on a lien. And we'll talk about bond claims, private, Little Miller Act, which are public state projects, and federal projects, which have Miller Act bonds. This is another interesting topic that I'll try to get to, which is quasi-public private projects, the ability to lien leasehold interest, liening a condominium, and some collection pointers. So let's start with the basics. Why would you want to file a lien? Well, in essence, it prevents the property from being sold. Now, that's not technically accurate. The property can still be sold, but what the lien does is it makes the owner of the property deal with your lien, either by getting it paid at the time the property is sold or bonding it off, which we're going to get to later. So that's one of the primary reasons you want to file a lien. It could put pressure on the owner to pay you because they need to clear the title to deal with the property, or they may have an obligation to the lender to have clear title, so that filing the lien may accomplish that purpose. For a subcontractor, if you file a lien, it puts pressure on the contractor to pay, because the contractor will be getting pressure from the owner to take care of the lien, and it's probably in the contract with the owner that says if there's a lien, you're going to deal with it, and that may require the contractor to bond it off or pay you or resolve it somehow. And it acts as another source of recovery, which is your interest in that real estate if somehow you don't get paid. You don't have what they call an in personam right, or a personal judgment against the property owner unless you work directly for the property owner. What it does, it gives you an interest in the real estate. It's called an in rem action, and your rights are perfected in that real estate. You couldn't sue the owner of the property and get a money judgment, but you would have a judgment which would allow you to eventually foreclose on that property, sell the property if it comes to that, and get your money out that way. So these are reasons why you may want to file a lien. You also may want to file one for a few $100s just because you don't like the contractor and you want to make his life miserable. And also may prompt the owner or contractor to obtain a lien discharge bond. So let's get into the liens a little bit more in Georgia. A lot of requirements in Georgia. Who can file a claim of lien? Contractor, subcontractor, supplier to a contractor, supplier to a subcontractor. So does a supplier to a supplier have lien rights? And the answer in Georgia is no. I'm not responsible for that traffic, by the way. And then what about a contractor or subcontractor who's required to have a license? This is becoming a big issue in Georgia, not only with liens, but just in general. There are contractors out there that are doing work without licenses. There's been several significant cases. It's really not part of the seminar today, but if you don't have a license, you don't have lien rights, and you don't have bond rights. And you could be in a whole world of trouble if you're trying to sue to collect, because you can't, and you may have to give back some or potentially all of the money you received. But that is a topic for another day, but these cases are developing and coming out fairly quickly as the issues arise, and we have, I think I've got about 5 or 6 pending right now where licensing by the contractor is an issue. But we know for sure if you don't have a license and you needed one, you don't have lien rights. Here's your answer on that one. By the way, there are others beside the parties I listed that have lien rights. Architects, registered architects, and in my 30-something years, I've never filed a lien for a registered forester, but apparently they have rights under the statute as well. You have to file your lien within 90 days of your last date of work or delivery of materials. Warranty work does not count. There are cases out there where someone went back when they missed their 90 days, and they claim that they had to make some sort of adjustment on some very minor piece of equipment at the project, and that will not extend your time frame. Punch list work does count, however. We have a lot of clients that are suppliers, and the issue comes up with counter pickup, shipment delivery to the contractor's office, or materials delivered to the job, but then they're removed. These become issues of fact that you're going to have to address. If they're picked up at the counter, you need to be sure that at the very least the invoice and statement identifies what project the materials are going to. Same thing if you're shipping them directly to the contractor's office. You need to be sure if you're a supplier that you're getting as much information as you can. So if you have to file a lien, at least you have a fighting chance. You may have to prove that the materials actually were incorporated in the job at some point. If all you have is a counter pickup or a shipment to the contractor's office, we've had instances in the past where they were larger items like mechanical equipment that we shipped to the contractor's office or picked up at the counter, and we actually took the plans out and we walked through the project and we identified the materials by serial number, because that was the only way we knew that they were there, and that allowed the client to then have a lien. If materials are delivered to the job and removed, you do not have lien rights, because the purpose of the lien is that you are being compensated for the improvement of the real estate. So some of the lien details, I know there's lien filing services out there. A lot of our clients that use these services, or anyone who's unfamiliar with it, just may not know the details because they have other people do this for them. But if you plan on doing it on your own, it's a dangerous operation to try, but you file the claim of lien in the county where the property is located. I've had instances where that property is in 2 counties, so you would have to file that same lien in 2 counties for it to be effective. The lien must contain certain information. It has to have the name of the lien claimant, that's you, the name of the property owner, the date the claim became due, and the amount claimed to be owed. There are cases where the lien claimant got his name wrong. He was actually a individual as opposed to a corporation, but a lot of people that have small businesses may call themselves Johnny Plumber Inc., and he's actually not an Inc. because he didn't incorporate, and he is therefore Johnny doing business as Johnny's Plumber Inc. And if he doesn't identify himself properly, that could be an issue. If you don't get the property owner correct, that could be a problem. And the reason I mention these is because a lot of people are Google lawyers, and they go online and they get the form from the internet, and these forms are not exclusive to Georgia, and they may not work in Georgia. You need a specific Georgia form if you're going to do this, and it needs to be filled out correctly. You must mail it within 2 days via certified mail to the owner and the contractor. Remail it to whoever we think we should notify in addition to the owner and the contractor. That may be your customer as well. If it's not the contractor, it may be the lender. It could be a surety. No harm in sending more notice. Recent changes to Georgia law requires that the lien include a statement which says that the lien will expire and that the owner has the right to contest the lien. Again, this is when I see people that use forms. This language is typically not in there. That is fatal to your lien. And that's what the language looks like. That's how we draft it. We put it in bold at the bottom of the lien form. This is the part where the owner has the right to contest the lien. We're going to get to that in a little bit. So just, I'll call this some bonus today for the seminar. Send a demand letter along with the claim of lien. Sometimes people that get them, especially homeowners, have no clue what it is. So you may want to put a cover letter and explain what it's all about. Make sure you keep track of your deadlines. For whatever reason, we get a lot of calls around federal holidays, Thanksgiving, 4th of July, Memorial Day, and people haven't been paid, and they say, oh, I haven't been paid. How long has it been? 2.5 months, and they send everything over, and your lien is due that Thursday when you're going to be off Friday, Saturday, Sunday, and Monday. I'm telling you, it happens invariably, and you're scrambling around to get a lien done. Don't wait till the last minute. Mistakes happen from everybody when you wait till the last minute. If you're not being paid, don't let your customer continue to sell you a bill of goods. Start the process at, say, the 75-day mark, and at least get everything over to whoever's going to file a lien for you, so that when you give them the go-ahead, they're ready to go. It's an unforgiving deadline. And there are ways to lose a lien before you get started. So in Georgia, if you're not in privity with the contractor and the contractor filed what they call a notice of commencement, you have to send a notice to contractor within 30 days of your first work or delivery of materials. So keep in mind, you have to know on every job where you are in the chain of command. If you have a direct relationship with the contractor, you do not have to send a notice to contractor. If you do not have a direct contractual relationship, you do have to send this notice. And the Court of Appeals are filled with cases on these issues. And I'll tell you how it comes up in a minute, but what happens if I miss my deadline? Well, some bad things will happen, but here's how it plays out. First of all, what's a notice to contractor? It's a written notice. It's sent by registered or certified mail or statutory overnight mail, and it has to have certain information. This is right from the statute. Name, address, telephone number of the person providing the labor. That's you. The name and address of the person who's asking you to provide the labor and materials. Name of the project, location of the project. If there's a notice of commencement, you can steal all that information from the notice of commencement and just regurgitate it on your notice to contractor. And if you know how much your work is going to be, or the value of your materials, you have to include that amount. The purpose of this is because the contractor doesn't know who his subcontractors may be dealing with, either by way of other subcontractors or material suppliers. So this notice to contractor lets the contractor know you're out there and allows the contractor to make sure that when he pays money, it works its way down to the people that should get paid. So how does the contractor protect himself? Well, he files the notice of commencement. And this is what triggers the notice to contractor. And the notice of commencement has to contain certain information as well. And this is a 15-day deadline for the contractor. After he physically commences work on the property, he shall file the notice of commencement, and it has to have certain information. And notice that on the third sentence here, it says the notice of commencement shall include. And you would think the word shall means shall, but according to the Georgia Court of Appeals, it doesn't always mean that. I can give you a specific example in a second. This is an important provision in the statute. If you are not in direct relationship with the contractor and you don't know if there's a notice of commencement, you can write to the contractor and ask him for a copy of the notice of commencement. If he does not give it to you within 10 days from receipt of your request, your written request, then you do not have to send the notice to contractor. A lot of times, if you're not sure, send the request, wait the 10 days, and then you're not obligated legally to provide the notice to contractor. So how does this all arise? I can guarantee you how it doesn't arise. Nobody who is supposed to send a notice to contractor ever goes to look at the notice of commencement, to examine it in detail and see if there's a mistake with it, and say, aha, they messed up with the notice of commencement, I'm not going to send a notice to contractor. That has never happened, that will never happen, and what happens is, the lien claimant files a lien, he was not in direct relationship with the contractor, contractor says, where is the notice to contractor that you were obligated to send me? And he goes, what are you talking about? He said, I filed a notice of commencement. You were obligated to send a notice to contractor. I wasn't aware of that. So now what do? Well, now you have to dig into that notice of commencement and see if it was something what the Court of Appeals calls fatal flaws, defects in the notice of commencement which relieved you of your obligation to send the notice to contractor. What are some fatal flaws? The failure to properly identify the owner. You mess that up in the notice of commencement, it obviates the obligation of the second-tier party to send a notice to contractor. What if you fail to provide a legal description? That is a fatal defect in your notice of commencement. Here's an interesting one. Remember, it said if you fail to identify the construction lender, that's also information required by the statute. If you fail to properly identify the person who ordered the improvements other than the owner, this is again one of those shalls that's in the notice that's required. So what if you fail to include the phone number? So this one came up. and we represented the contractor, and there was a lien filed, and the lien claimant did not provide a notice to contractor. He said, your notice of commencement was faulty because you did not include your phone number in the notice of commencement. And remember, it said you shall include that information. Well, on this one, we escaped. The Court of Appeals said, even though it said shall, we argue that it's not something that would ever really be necessary or particularly material, because you could never give verbal notice over the phone. So even though our client failed to provide his phone number in the notice of commencement, it wasn't fatal in that case. Let's move on. You filed your lien. Well, now what are you supposed to do? There's more deadlines, believe it or not. You have 365 days during the date you filed your lien to sue the party that owes you the money. That lawsuit will trigger yet another deadline to file what they call a notice of commencement of lien action. This is not the same as the notice of commencement filed by the contractor. It's a separate document. Notice of commencement of lien action must be filed with the county where the lien was filed within 30 days of the filing of the lawsuit. You missed this deadline, you lost your lien. The notice of commencement must contain certain information. I'm not going to read all that, but I'll show you what one looks like. So this is one that I did, and
You got a question?
I'll get to the question. So we filed this, you owe us money versus we don't have the money. I blacked out all the other information, but this is the form that we use. Has to have the owner of the property that's affected. You have to show something in the chain of title, whether it's a warranty deed or some other instrument. You have to identify where you filed the lawsuit, case number, the date you filed the claim of lien. Whoever has a question on public property, we're going to get to that in a minute, but there's no liens on public property. I can tell you that firsthand because there's a case on point. What if, and here's a couple of scenarios that may come into play. Sometimes you don't have to sue the party that owes you the money within that 365-day period. Statute provides some exceptions. Some of them are that if the debtor has absconded or can't be found within the jurisdiction, you can bypass suing the party that owes you the money and go after the owner directly to foreclose your lien. Contractor filed bankruptcy. Obviously, you can't sue him because there's typically an automatic stay, so you can't sue the party that owes you the money. Or if there's a pay-when-paid clause, which provides the contractor with an excuse not to pay you, then again, you can bypass suing the contractor. If you have a reason that you don't have to sue the contractor, it will still trigger your obligation to file a notice of commencement of lien action. And here's another bonus. If you miss your notice to contractor, examine the notice of commencement. You take a look and see if there's one of these fatal flaws in there that you can escape some heartache. Georgia came up with a new procedure several years ago called a notice of lien contest. And what this does is, like I said, you typically have 365 days from the date you file your lien to file suit against the party that owes you money. Sometimes the owner of the property doesn't want this lien on their property for that long a period of time. They can file a notice of lien contest. That forces you then to sue the party that owes you the money within 60 days. If you don't file the suit within 60 days, then you've lost your lien rights. When you file that suit, you have to file your notice of commencement of lien action. The only exception is if your lien's been bonded off before that 60-day period, before the 30-day period, to file your notice of commencement of lien action, you don't have to file it. What's a lien discharge bond? So a lien discharge bond removes the lien from the property and clears the title. It's equal to the amount of the lien on a residential property, and the bond is double the amount on a commercial property. I have a lot of clients that call up and go, they've threatened to bond off the lien. What do I do? I tell them, send them a thank you note, because it makes it a lot easier to recover on a lien discharge bond than it does to foreclose on a piece of property, pay off all the mortgages in front, have it sold at the courthouse steps, and hope there's some money left for you. So they're doing you a favor when they bond it off. It's the same as them going after basically a surety bond. You still have to meet all of your obligations to perfect the lien, to prevail on a lien discharge bond. None of the requirements are waived, by the way. So let's talk about something that's in the news now for lawyers and all of you in the construction business, lien waivers. Georgia uses statutory lien waiver forms. They use interim and final forms. If you use the wrong form, if you're a general contractor and you've got your subs using the wrong form, you've got a problem. It's invalid. Make sure you're using the right forms. Georgia law does not allow you to waive lien rights in advance of providing labor or materials. So I've seen contracts where the contractor puts into the subcontractors, it says you will not file a claim of lien on the property, unenforceable. What if I sign a lien waiver and don't get paid? Well, that's a problem. Georgia really sets things up in a bad way, in my opinion. These waivers that you sign, the system is if you sign the waiver and you don't get paid, and that's as of today, by the way, we're going to get into the change. If you sign a waiver and you don't get paid within 60 days, then, and you don't undo that lien waiver, you've lost your lien rights. You have to keep track of your deadlines. If you ever sign a lien waiver and you don't get paid the money, keep track of, well, we're going to get to that. You have to file what's called an affidavit of non-payment within 60 days from the date you sign the lien waiver. It's a special form. It has to be signed under oath. It is filed in the county where the project is located. As of today, you can also undo a lien waiver in which you did not get paid by filing a claim of lien. The deadline to file your affidavit of non-payment may be longer than your deadline to file a lien. So don't assume that because you have 60 days to file an affidavit of non-payment, if you haven't been on the job within 60 days, you may have to file your lien, which is fine, but that will undo the lien waiver. So you have to really know your deadlines and when you sign things. You signed a lien waiver, you did not get paid, and you did not file an affidavit of non-payment. Now what do? That's very bad for you for the next 3 weeks, and I'm going to tell you why. Last time I gave this seminar, and I've got proof because I showed Andrew the other day, I put a little comment in my presentation that said, you know, you really read these lien waiver forms in Georgia closely. It says you've lost not only your lien rights, but basically all your rights, the way the statute read. And there were no cases that said what the language in the lien waiver meant. And I said, you know what, if you read this literally, I bet you lose your contract rights. It is really a harsh result. I don't think the legislature meant that, but that's what the language says. You lose all rights for all purposes. And someone picked up on that, and it was a recent case. And I'll give you the citation. It's a case of ALA Construction Services versus Controlled Access, Inc. For those of you making notes, 351 Georgia Appellate 841. This was back in the fall. And this is the language that they looked at. When a waiver and release provided in this code section is executed by the claimant, it shall be binding against the claimant for all purposes, subject only to payment in full. So it was that language for all purposes. What the court said, we conclude that the plain and ambiguous language of code section clearly provides that the General Assembly intended the waiver to be binding against the parties for all purposes and not just for the purpose of preserving the lien on the property. So what happened is this guy lost his contract rights. And I don't believe the legislature ever intended that. And so kudos to the legislature and the governor for immediately enacting a law which will go in effect on January 1st. And it changes this. And it's found at 4414-366. And what it does, the new law, this is the old law, which you're operating under through the end of the year, affidavit of non-payment. Here's the new law, Senate Bill 315, but it's codified in 4414-366. Lien waivers do not waive contractual rights anymore.
One thing I would add to that is I'm familiar with this, and AGC and some of the other construction associations were integral in getting this recognized and this legislation supported and passed. So, you know, to the extent that y'all on this call are members of those associations, that's who you can thank for it. And thank goodness they're out there watching for crazy stuff like this, because they really have done yeoman's work on getting this handled quickly.
This came down pretty quickly. You now have 90 days to file an affidavit of non-payment as opposed to 60 days. And a filed lien, and I'm not sure I particularly understand why they put this. There must be a reason, and we'll look into it more. But a filed lien will not be a substitute for an affidavit of non-payment like it was under the old law. So the way I read this, if you sign an affidavit, a lien waiver, you don't get paid, you file an affidavit of non-payment to undo it within the 90 days, and then if you still haven't been paid and you're within your time frame, you file a claim of lien. Very important that if you're signing a waiver within the next 3 weeks, you're subject to the old law. So conceivably, a couple of weeks into January or whenever your waiver expires, if you don't undo it within the 60 days, you may not only lose lien rights, but contract rights. Just a couple more things when it comes to liens. Sometimes we've had clients to deliver material to undeveloped land. This becomes difficult. All I will say is just try to get as much information as you can when materials are out there with undeveloped land. It may not have a street address, may not have a lot of details. You have to do your best to figure out where this property is and get a meets and bounds description so that your lien is enforceable.
Is it okay to describe a property with like GPS coordinates or?
Whatever you could just do a street address, that's fine,
But sometimes, to your point, they don't have them assigned yet. And,
So I'm a belt and suspenders type of guy. I'll throw in whatever I have. Just there's cases that talk about providing what they call a key that refers to something else. So maybe there's a plat you could refer to or attach the plat. But I throw
tax ID.
Tax
Sometimes
ID,
we'll do it, or there's it can be tough, especially if it's in a rural area.
Yeah, it doesn't happen very often, right? You know, something happens once, you stick it in your mind and figure out share it. Same thing, property in more than one county, file a lien in both counties. Can you amend a claim of lien? Yes, recent amendment to Georgia law allows you to amend it if you want to lower the amount. You know, typically if I have a client that gets paid part of a claim of lien, unless they're chirping at me, I don't usually amend it lower, I just leave it. But they may want to bond off the rest of it, so if they ask you, you probably need to do that. False affidavits, you should be aware of these. I'm not going to touch on it too much, but if there's a false affidavit issued under certain circumstances, it can wipe out your lien rights. Typically, it happens in a residential setting where you may be the last man delivering materials or doing work at the project. Contractor finishes up, there's a closing. He signs an affidavit and says that he's paid all the bills. Conveying title in a bona fide sale, final disbursement of the contract price, these are the more typical ones. So the builder files an affidavit saying everybody's been paid. If that's false, you've wiped out, your lien rights have been wiped out. Now, you have a claim against the contractor for false swearing. And you also, this is one where I wouldn't give up hope. I would also get with, if there's enough money and you want to get involved with, litigation, then you want to know if the owner knew the affidavit was false. Sometimes the owner might be in cahoots with the builder and says, why don't you sign this affidavit, nothing will happen. If the owner knows it's false, it's not going to be effective to wipe out your lien rights, but generally speaking, it can. If there's a contract with an anti-assignment clause, you may not have lien rights. There's a case out there that if there's an anti-assignment clause in the contract and it's assigned to you and you don't get paid, you don't have lien rights. So this ties in with what Andrew said and what we were discussing is you probably want to get a copy of the general contract if you're a subcontractor and see if you are allowed actually to subcontract out your work. Because you may be out there working and not aware that it's a prohibited assignment of the subcontractor.
Pretty common to have that where it says without permission or something like that.
Yeah. Right. I will say, and we usually try to change it so that it says won't be unreasonably withheld, but most contracts these days say no assignment, no subcontracting. The only thing that you can do is you can assign your rights to receivables to a factor. That's about the extent of it.
I think we have a question about where we could get the forms, the new forms.
They're in the statute, actually.
Okay.
So if you have a 4414-366, they give you the forms to use. And those are the ones we use. This is a question that for years, everyone thought that once you filed a claim of lien and did everything you needed to do to perfect your lien, that you could just let the lien sit there forever. That's not the case anymore. Recent case said that my clicker's not working. Doesn't happen that often again. This is foreclosing a lien. Again, foreclosing a lien doesn't happen that often in all the years I've been practicing. I think I've maybe done it once, to be honest with you. It's more to create the leverage, but in any event, we used to think that your lien could just sit there once you've done everything you needed to do, but recent case that your lien is only as good as your underlying judgment, which is 7 years. You can renew a judgment in Georgia, but basically speaking, you better do something within a 7-year period. You cannot recover attorney's fees against the owner on a claim of lien. You can't get interest against the owner. So let's move quickly to payment bond claims. A couple of pointers, as I mentioned earlier, there are public works bonds and private bonds. You may have both lien rights and bond rights on a private job. They are independent rights. You want to pursue both rights. For some reason, maybe your lien's messed up or you didn't give the notice to contractor. So you want to do both the bond and the lien rights and pursue them and see how you're going to get paid. Public work projects in Georgia, $100,000 or higher, requires a payment and performance bond. Miller Act, which is the federal act, requires bonds on contracts over $100,000. Oftentimes, there's private bonds issued for private projects in Georgia. Almost under all bonds, the very least private bonds, the subcontractor will be covered. You have to look at the bond itself to see what the terms are, but the notice requirements on private payment bonds issued on private projects track the notice to contractor. Same thing, depends on where you are in the chain of command on the project. Little Miller Act is the Georgia statute for bonds on the public works. Same mechanism with the notice to contractor, notice of commencement applies for these claims. Much broader coverage in Georgia extends down to suppliers is not as broad under the federal Miller Act. So again, you need to know where you are in the chain of command on a project, especially a federal project. Deadline to sue on the bond is 1 year from the completion and acceptance of the project. That's the Georgia Act. Yet another deadline. Federal Miller Act is a federal project. Federal law from 1935. If there's a contract with the United States or any department or agency, over $100,000. Make sure it's a federal project. Usually it's pretty straightforward, Army, Navy, something like that. I had a case years ago where it was a post office. It's actually private property. So don't just assume that what you think might be a federal project is actually a federal project. What does the Miller Act say? It says, although the payment bond is intended to protect all persons supplying labor and material and carrying out the work, it's actually limited to sub-suppliers, laborers, who have direct contract with the general. Contractors, suppliers, and laborers who have direct contract with the sub of the first-tier sub. Third-tier parties not covered under Miller Act. So it's narrower than the Georgia Little Miller Act. What's due when? If you do not have a direct relationship with the contractor, there's what I call a tail end notice. You have to send notice within 90 days of your last day to work, and you have to say you haven't been paid, and you have to send it to the contractor by certified mail, stating substantial accuracy, the amount that you're owed, and the party you provided the labor and materials to. Has to be sent certified mail. Send it to the surety as well. Again, one of these, send it to anybody that really cares or may have an interest in what's going on with your non-payment. If you contracted directly with the contractor, you don't have to send this 90-day notice, but there's no harm in sending it. If they'll pay you without you having to make a bond claim or filing a suit, then it's preferable. You cannot sue before the 90-day period expires under the Miller Act. Deadline to sue in the Miller Act, 1 year from the last date labor and materials provided to the job. Not the same as under the Little Miller Act in Georgia, which is 1 year from when the project is completed and accepted. So it's typically shorter on a Miller Act job. Suit is filed in the United States District Court where the project is located. The actual caption of the case says your name for the use of the United States for the use and benefit of. So there's a special caption of the lawsuit when you file it. Georgia, if the surety acted in bad faith, you can possibly get attorney's fees. You have to give a 60-day notice. Miller Act, maybe you can get attorney fees if your underlying contract provides. They may be recoverable. Usually you can get interest on both of those bonds. And you have to sue in federal court. Suit is brought in the name of the United States on your behalf. You still have to sue even if you have an arbitration clause. That's different than a filing suit in Georgia if you're trying to foreclose a lien, by the way. And if you had a good faith belief your materials were going to the job and they were diverted, you're still covered. That's totally different than lien rights where you have to actually have your materials incorporated into the project. That comes up quite a bit, actually. This one can give people headaches. I don't know if I'm going to provide any great answers at the end of the day, but there are a lot of projects out there. Just doesn't seem fair. These are contracts between development authorities and corporations. And the corporation typically, a private company owns a piece of property. They then sell it or transfer it to a development authority. You see a lot in Fulton County, but it's all over. Fulton County then becomes the owner and they lease it back. So why does this create a problem? Well, number one, for whatever reason, a bond is not required when construction work is performed on these projects. Number two, because it's now publicly owned, you cannot file a claim of lien. So you're in no man's land on these things, and I have filed liens on them. I've not gotten any nasty calls to remove them. One day, one of these will come up. The closest thing I had was several years ago was a situation like this. The project ultimately was going to be used by individuals that were buying the house for, and they would be titled in the individual's name. And I argued that the end use of these properties are for individual private owners, and the Court of Appeals said, sorry, you're out of luck. Building these houses was a activity of the housing authority for the public benefit and welfare, and even though the properties were ending up in individual names, you don't have any lien rights. And I don't know if there's been more since that case, which has been 15 years or so, but this is one where it may come up again. Leaning a leasehold, you have the right to file a lien on a leasehold. You have to know about the lease. You have to know about whether the landlord is providing any tenant improvement money, and you have to know the length of the lease. So I'm not going to get into this. This is a topic for itself, but keep in mind that you can lien a leasehold. Typically, when there's a lease involved, we lien not only the underlying property, but the lease as well. We do two separate liens just in the event that one of them is unenforceable. We don't have to undo both of them.
That's where you're working on an interior build out in an office building typically, or some kind of building.
You can also lien a condominium project. Again, not the point of this seminar here today, but just bear in mind that if it's a condominium, you have the ability to file a claim. Let me just talk briefly on payment bond claims. So you don't get paid, you make your claim on a payment bond. I represented sureties for years, so they'll send you back a letter and say, send me this claim and affidavit form, send it back, send me all your documents, and we'll look into it. The surety then takes that information. They're supposed to contact the principal, do an investigation, and make a prompt resolution of your claim. That rarely happens. If their principal tells them that this claim should be disputed, the surety will dispute the claim, because if they pay it, then they're fighting with their principal to get the money back and fighting your battle. So I don't usually give a lot of leeway on payment bond claims. I give them everything they want. I allow them the time they're allowed in the bond to report back and make a decision, and then we just file suit. So that covers the payment bonds and the liens, which I think was the subject of my discussion. And if anyone has any questions, just let me know.
If anybody has any questions on either of our presentations, our email addresses are up, and you can send us emails, and we'll be glad to respond to the extent we can. Not every question has an answer, but most do.
Red.
This is not working. This is Doug Reeder. We had a little bit of an internal miscue on the number of slides and the length of the program, so we've run a little bit long today. I had intended to run through a handful of slides. I think we're going to defer that and kick that out into a future program. We definitely appreciate everybody's participation. I know we had a quite a large group, and I think there was a number of really good takeaways from both programs. And so I'm certain that hopefully everybody on the call has some nuggets to take back to their businesses. Thanks very much. And with that, we're going to wrap this up. Have a great day. Sorry about this. No, fine. Trust me.